everybody. My name is Nick Neidl. I'm a business and startup consultant at the Chamber of Commerce in the city of Dortmund. And I'm one of the main organizers of the Startup Germany tour. As maybe a few of you already know, this Startup Germany tour will be completely realized digitally. It will take place from October 25 to October 28. And the tour will give startups, especially from the insurtech, smart city, and the logistics and mobility sector, the great opportunity to get deep insights into these sectors. And it's an exciting event to connect with other startups and even with multinational companies from the region, Nordrhein-Westphalia. Today, it's the third webinar of this pre-program, and we would like to give you some information and content about the legal framework in Germany, especially our experts from Deloitte. But before, I want to thank NRW.INVEST for supporting us in realizing the tour and today's webinar. NRW.INVEST is it's the first address for helping you in making the first steps in this region, Nordrhein-Westphalia. And therefore, I would like to introduce to you my colleagues from NRW.INVEST, Mrs. Elena Matekina and Mr. Christoph Sommer.
Hello, everyone from Düsseldorf, from Germany again. I'm Elena Matekina. My colleague Christoph Sommer and me represented the Economic Development Agency of German state of Nordrhein-Westphalia. Last week, some of you participate maybe in our 2 webinars as part of pre-tour for the Startup Germany tour. And last week we met Dr. Filling from the designer of our ecosystem in NRW, Dr. Heise from NRW Bank, Oliver Weimann, manager of Ruhr Hub and host of the annual Ruhr Summit, one of the largest startup events in Germany. On Friday, we have a topics 5G NRW and logistic NRW. Starting today, you can download the recording of these webinars. And today, in the next few days, you will learn a little more about the federal state and especially why our region is the right place for your business and why the collaboration with company from our state could be a good plan opportunity for future. Very short about NRW.INVEST. We are state-owned economic development agency. We belong to state government in Nordrhein-Westphalia, represented by the Minister of Economic Affairs. We're based in the state capital, NRW Düsseldorf, and beside 2 subsidiaries in Japan and USA, NRW.INVEST operates representative offices in China, India, Israel, Korea, Poland, Russia, Turkey, and the United Kingdom. We work aboard closely together with the German Chamber of Foreign Trade in countries and with Chamber of Commerce and Industry in NRW. Our mission, we support the companies from Germany and abroad in the implementation of business project in NRW. And before we heard our main guest from Deloitte, short information about the federal state by Christoph Sommer, my colleague and significant expert and accompanying startups in NRW with me. And he know the needs in international startups very well. Christoph?
Yeah, I want to keep it very short and simple on this late afternoon, depending on where you're located, in which time zone around the world. So you might have already late night or early in the morning, so a very warm welcome Also from my side, from NRW.INVEST, as said already by my colleague Elena, the state-owned economic development agency of North Rhine-Westphalia. So we are hosting today's webinar about the legal framework in Germany, as this is one of the crucial things you should deal with at the very first beginning when coming over here, expanding your business, as already also introduced. I'm quite, I wouldn't say an expert in the startup business, but as I'm leading the Inter Alia, the business unit for Israel, my daily business is around startups and expanding their business to Germany and also quite naturally to North Rhine-Westphalia and NRW in short terms. And 2 sentences, and then it's already, that's it from my side, to spare the time, of course, for the legal framework and all that stuff attached to that, is that we are by far the most important economic region in Germany. So when expanding here, we have on the one hand national and multinational large-sized corporations on the one hand, be it national one like Bayer, Lanxess, Evonik, Henkel, and many others to name, but also the mixture of small and medium-sized enterprises on the other hand, with more than 700,000 on the other hand, make it a very attractive, especially in the field of B2B markets, to come over here, to look out for POCs, for new customers, clients, to get in touch with clusters, get embedded in ecosystems here. And this is where NRW.INVEST, as the state-owned organization, can also, besides many other different kind of points, can be of great help with you guys out there. So also after the today's webinar and in upcoming weeks for the Startup Tour Germany, feel free to get in touch with each and other of us. And so now I'm giving the word to our colleagues from Deloitte to talk a little bit more about the legal framework in Germany. So, and feel free to ask any question you might have at any point. Maybe you could use the Q&A function, making it for us a little bit easier than the chat function. But nevertheless, everything will be answered also afterwards if there's something left. So, but feel free to use this chance to ask anything you want to know from those experts out there. And please go ahead.
Thank you, Christoph. I'm happy to take over to introduce to you what we are going to present to you in the hour or so to come. My name is Jörg Wiederhold. I'm a Deloitte partner based in Düsseldorf. Until October of last year, I was based in Prague, where I spent 6 years mainly working for companies from the German-speaking world that have an interest, have subsidiaries in the Czech Republic. I had already been in a similar role during a 3-year secondment to Poland previously, and a 6-year secondment to Romania. Now that I'm back in Germany, in Düsseldorf, I'm the face of Central Europe inside the German Deloitte firm, if you like. I'm an audit partner, but I also have a strong interest in all matters having to do with international tax, which is the aspect which I'm going to cover myself on this call ever so briefly. I think when Mrs. Matekina, when Elena Matekina approached me about a possible cooperation for this webinar, I immediately said, yes, it's a very good idea. And I said so because I know from my own experience from the various secondments that we have a lot to contribute. And I'm certain that we will be able to help you make up your mind in deciding when and how to come to Germany. My colleague Tobias Fuchs is now going to take you through the agenda in a little more detail, and then we will jump right into it, and you'll hear from me again in 2 places on taxes. Tobias, over to you.
Excellent. Excellent, Jörg. Thank you very much. I'm not sure is my micro open already?
Yes, I think your micro is open, Tobias.
Okay, my name is Tobias Fuchs. I'm also a partner within Deloitte Legal, and I'm heading the digital business practice. And as you may imagine, we have lots of people who are pretty much into the topics that usually eventually venture builders and entrepreneurs with startups are confronted with. And I brought to you three of probably my best people here. The first is Nikolai Wessendorf, who is counsel and in a sense is an expert on regulatory laws and data protection specifically. The other one is Sebastian von Rüden, who is an absolute expert on IP, know-how matters. And the third one is Sven Timmerbeil, who is an expert basically originally in the M&A and venture building topic. And these three, together with you, Jörg, will give you now a little bit more insights into basically three topics. We will start with the topic expansion to the German market. So they will talk about the business through local subsidiaries on the one hand and services from abroad, specifically tax implication. Jörg and Nikolai, you will take over this. In a second part, we are talking about the venture building in Germany. How to start, what to consider when a company is built, and registration requests, and specifically also capitalization. Sven will take over this block. And the third and the last one is the typical challenges and hurdles in specifically venture building, specifically for startups. And we choose three topics: the IP, intellectual property, and know-how thing. This takeover by Sebastian von Rüden, as well as the commercial and consumer rights and the regulatory topic with a specific insight into data protection and specific insurance matters. So I'm happy that we can start now with our topics, and please feel free to bring your questions on the table, and we will look that we have a good conversation, and we'll try to respond to all questions. Thank you very much. And Jörg, Nikolai, you want to take over?
Yes.
Right.
Thank you very
I'm
much.
happy to let Nikolai go first.
Great. Thank you, Jörg. Jörg, Tobias, thank you for the great introduction. Everyone out there, I'd say welcome to Germany. A great choice to look into the option to expand to Germany, to North Rhine-Westphalia. Take this moment also to think a bit about the regulatory, the legal requirements, the legal framework, which might not only infect you, but for sure will impact you and your venture. So we're happy to give you a bit of insight. Of course, within an hour, presenting the whole legal framework in Germany would be a little bit too much, but I think we focus on great and interesting aspects, which probably will be the first questions you'll have when looking into the option to go and start your venture in Germany, or even bring services from abroad. There are basically two options you're probably looking into, right? You're thinking about building up a local subsidiary, a local business. You maybe already have your business outside of Germany, maybe outside of the European Union, and you're wondering, what can I do? Do I have to go to the German market by actually building a subsidiary, building a company in North Rhine-Westphalia, beautiful city of Düsseldorf, Cologne, or anywhere else? Or can I do my business from abroad? Can I do it because it's online and web-based? Can I do it from everywhere you are at the moment? So these are probably the initial questions you'll have. We try to give some answers, and we'd start with the first one, doing business through a local subsidiary, through a local company. There are actually two options you have. Maybe you are in the lucky situation that you're coming from another European Union member state. Then things are a little bit more easy. Obviously, we're going to help you also if you're coming outside from the EU, because obviously we're looking forward to have you here. But from a legal perspective, there are some differences, right? So when you are residing in a state of the European Union, which is currently 27 member states, you have certain privileges. But not only that, also when you're from the EEA area or from Switzerland, things might be a little bit easier for you when you look into the option in setting up your company in Germany, in North Rhine-Westphalia, or actually starting business here right away. European law gives you a lot of options and actually guarantees you certain elementary freedoms, which are, I've listed them here on the slide so you can easily see them. It's basically free movement of goods. So within the European Union, basically goods need to flow without borders. That is the whole idea of the European Union. No borders, no boundaries, doing easily business from one state to the other. The other one is providing services. So for example, you're residing in Austria or in France, and you would like to provide services to Germany, to Nordrhein-Westphalia, you can do that. And there can't be any hurdles, because any hurdle would be considered a discrimination, which you could oppose to. So another good news. When looking at the freedom of establishment, and that is something very relevant for you, you are protected. Your right is protected to build a company in another country. So for example, to go and start your business in Cologne, coming from Lithuania or from another European member state. And you need to have the same access, to you need to have the same rights as a German building up a company in Germany. Then you have the free movement of workers. Maybe nothing for you relevant for the moment, meaning you're probably all entrepreneurs, you're probably all founders, so no employees. But when you're looking into the option to actually hire people, to get people from another European member state because they're very much qualified and they're a great resource, you can easily recruit them from any other European member state, and there can't be any hurdles recruiting them and getting them to work for you in North Rhine-Westphalia. And then in the end, free movement of capital, obviously, all that is not going to work if capital can't flow easily. So you have full protection there that within the European Union, that will be as easy if it was only one state. For the rest of the world, unfortunately, there are no equivalent privileges in first place as a general rule, but, and there is a but, obviously there are international treaties, there are arrangements and also cooperations certain countries have set up to facilitate the expansion to another country, right? There are programs set up by individual countries to actually pull you and to get you to Germany. So wherever you are, we recommend to look into options whether there are some privileges and where things are made easier for you to come to Germany. So for the rest of the world, and this is something maybe you want to look into a little bit further, when you are looking into the foundation of a company in Germany as a non-EU national, you need to bear two things in mind. So if you want to come as a founder here to Germany and set up your company, you need basically two things. You need either a temporary residence permit or a permanent settler permit. These are two titles that actually allow you to stay in Germany. The permanent settlement permit is something you usually get when you're already here for 5 years or within the European Union. So that's something that would require that you are not a national, but still you have already a permanent settle permit. Makes things very much easier, but probably it's the other option. Probably it's the option temporary resident permanent, right? So how can you get that? How can you get that permit to actually start your business? Of course, there is a law governing all this. This is the German Residence Act. And this is addressed to self-employed. Self-employed is basically everyone that is not employed, right? So there are some distinctions. You got to be careful when you're the manager of a company. Certain conditions need to apply, but in general, that is the way you go. So to get a temporary residence permit, you need to fulfill certain criteria. When starting your business, you need to prove and somehow demonstrate to the authorities where you're applying to overriding economic need or regional need for the business you do, right? And then you need a prospect of positive effects on economy. So you're contributing something, you're doing something great, you're bringing forward North Rhine-Westphalia, Germany, and the whole ecosystem around you. And then you need to have a secure finance. Coming without finance can be challenging, right? So getting funding is obviously, when you do venture building, something you really want to do at the beginning, also to prove secure financing to the authorities. How are the authorities looking at that? The key factors for the evaluation of this criteria is mostly viability of your business idea. Is this working what you're doing? Is there a prospect? Will you be successful? Of course, this is not a decision, you know, the hurdles are not that high that, you know, it must be for sure that you will be the next Amazon, but there needs to be a chance, right? And you need to somehow demonstrate that chance. Some entrepreneurial experience, of course, can be challenging when you're young, when you're starting your business, but also they would look at your track record, where you're coming from, how you appear. So no worries, there is a chance for everyone. It doesn't require necessarily age long of entrepreneurial experience, right? So, and then the level of capital invest, how much capital can you bring? What will you be bringing? And then of course, what effect will that have on employment? Will you probably employ people? Will you support the whole sector? And especially, will you contribute to innovation and research? As you know, Germany is an innovation-driven country, the country of the engineers and the land of the ideas. So whatever you can contribute, show that, and things will go their way. Further, something you need to think of as well is when you look into the business, there is, of course, and you got to the point that you actually start your business, there's a lot of regulatory, but all that can be handled, right? You just need to look in the right places, ask the right people, and you get the information. For example, there are restrictions on the activities you do. Do you need a permit? Do you need a special authorization to start your business? Do you need to have an expertise check? You need to prove your expertise in a certain field. In particular in insurance, when doing insurance distribution, for example, you need to prove your experience in that field. And then sometimes starting a business requires simple notification to certain public authorities. So you will find a lot of information. You have people like us and people from NRW.INVEST and others that guide you through that and provide you with information and help you to get settled. Then maybe over to Jörg. You can maybe give it some interesting insights when starting a company, a subsidiary maybe here in Germany, while you're residing from somewhere else.
Sure. I want to be very brief, and I'll only make a very basic comment on taxation. So whenever you have a parent company, a parent corporation that sets up a subsidiary corporation, you need to think about taxes basically in three places. Taxation will almost certainly occur at the level of the subsidiary company which you set up. Number two, when that subsidiary is profitable, once it has become profitable over time and starts paying out dividends, there is a strong possibility that that dividend will get taxed at source. I'm talking about withholding tax. So tax will or might be withheld by the state in which that subsidiary is domiciled. And the third place where taxation might occur is on the receiving end. The state where the parent company is domiciled may want to subject the dividend received to corporate income tax. Now, if the parent as well as the subsidiary corporation happen to be located inside the European Union, it becomes a lot easier because there is a directive, and it has been effective for a number of years already, a directive which provides for two things. Number one, there is no withholding tax when the dividend is paid. Number two, except for a small, if not tiny portion of the dividend received, the receiving parent company doesn't have to pay tax on the dividend. What I've said applies to a distinct set of cases within the European Union. It also, by the way, applies when both the parent and the subsidiary are based in the same jurisdiction, in the same European member state. There may be other situations, other setups where this doesn't apply, but I've selected this one, I've chosen this one to talk about because it's very common. It addresses the majority or the vast majority of cases of cross-border investments within the European Union. As soon as your parent company is not within the European anymore, things of course become different because the directive which I mentioned doesn't apply, at least it doesn't apply directly anymore.
Okay. Thank you very much, Jörg, for that perspective. It's for sure that when you look into building your venture in Germany, of course, tax implications are as important as legal. So always bear that in mind too. Maybe something not you're looking at the beginning, right, Jörg? But this can have huge impact at the end. So big benefits, but also challenges. So it is as important as this legal structure of your company to think about, where do I need to pay taxes when, right?
It might not seem important at the beginning when there's no profit to be taxed, but clearly the aim is always to become profitable over time. And many companies have come to regret not thinking about the tax implications when they first started. And this is why I brought this point up.
Thank you. Yes. So the other option is we want to look in quickly is bringing your services from abroad. So these days, and this is no secret, most of services, especially online related virtual services, are easily carried out by online means. So through the internet, websites, mobile devices. Many services, for example, come already from maybe even directly from the Silicon Valley, from India, from somewhere else where the companies reside, where they have their headquarters. In most cases, they don't even have an office in Germany. So there are options to come to Germany and do business here and be successful and have a German market, and while providing your services from abroad. So just a quick look what that means. Again, when you come from the European Union, I wouldn't say it's a piece of cake, but it's definitely easier. So that means you should, and you will have the same rights, the same freedoms as any other company doing locally business. So you can provide your services cross-border. There is even a great advantage, and we won't go into that, but the European Union is working for a harmonized market, a harmonized legal framework system, as the European Union is aiming towards a common market. So the idea is that basically all the rules and all the laws apply in every country the same way, which is not yet the case, and there will be a lot way to go, but it makes things easier, as we hear at the end when Sebastian talking about brand protection, but also when we learn a little bit more about regulatory aspects, which are mostly determined by European law. So when you come from the European Union, it is easy or easier to provide services, for example, in Germany directly. But still, we strongly recommend to get familiar with local regulations, with local habits and customs, and maybe also local interpretations of law, as they can be different. From the rest of the world, again, this is something you really need to look into closely. While it is so simply to open up your website, maybe even translate your website in German and do business for a German customer base, suddenly German laws apply for everything you do over the website, or most things you do over the website. This is not only data protection laws, for example, or regulatory laws, but also tax laws may apply, which Jörg will give us a bit of insight at that moment. So be careful, get involved, get interested, not only because you're far away, maybe geographically, and you feel it is easy to enter the market. It can have implications to your local business, but potentially even to where you reside. So we strongly recommend to look into the circumstances, get familiar with local laws and regulations, and also watch out and look for bilateral and multilateral agreements that might help you and might facilitate providing services from abroad to Germany. But Jörg, do you have an insight from the tax perspective here?
Yes, I do. And again, I would like to just highlight one set of circumstances. So the situation is different from the one we had before, because there's no German subsidiary. Suppose all your services were actually provided from abroad. If you do not have a sales organization in Germany, you are very likely to get away without being taxed in Germany at all. The situation becomes different once you have, say, offices, you have certain business going on physically in Germany, you have representatives going out in Germany to sell your services, you may well then have what in tax terminology is called a permanent establishment. And once a foreign entity has a permanent establishment in another country, it will most likely get taxed on the portion of its total profits relating to that permanent establishment. If you have no permanent establishment, no taxation. That's basically the rule as it exists. And why do I emphasize as it exists? Well, there is change on the horizon because the OECD is working on a major overhaul of what I would like to call the international taxation system, the way different states divide up the tax base between them. And the main thrust of that overhaul is to emphasize more strongly where the clients sit. Apply to the situation we are looking at, this may well mean that in 5 years from now, you will get taxed, if you are a foreign entity, you will get taxed on a proportion of your total profit in another country, even if you do not have any permanent establishment there and just have a client base there. So the nexus will be the clients. Once customers are present, this will be enough to trigger translation. This is a major, or it would be, I need to say, it would be a major change compared to the existing situation.
So better than right away come to Germany, Nordrhein-Westphalia, invest and build your business there, enjoy a good beer and in the old city of Düsseldorf or Cologne and start your business right there without bringing from abroad. In the future, at least, this would be also from a tax perspective, at least, not contradictory.
Come to Düsseldorf fast.
Great. Okay, so let's start looking into venture building in Germany with my dear colleague Sven.
Thank you very much, Nikolai. When you have decided to enter the German market and to establish a business in Germany, you have to make multiple decisions, and it's like a road you have to take. Some decisions have legal aspects, other are tax aspects, as you have already heard, and there are also administrative aspects. For example, you have to consider where you have to locate, for example, in the nice city of Düsseldorf, what costs you have to expect, which purpose your business should serve, etc., etc. And in the context of all these questions, you have to consider and you have to answer to yourself the legal aspect, the aspect which legal structure you should take, you should choose, and which legal structure serves your purposes, your interests best. This is what I briefly want to discuss with you now, and maybe Nikolai, you can go to the next slide briefly. I can. So how to start in Germany? Actually, you have a variety of types of legal entities you can choose. You will see here a selection of several entities. Some of them are used more often. Some of them are actually not suitable for small businesses or for a new start in Germany. As you can see, we have the stock corporation, for example. That's a legal type of entity used by big German companies, similar with respect to the European stock corporation. You see partnerships. Partnerships are usually not so popular when you enter the German market or start a startup. Why is this? Because you fear liability, personal liability. The shareholder is liable usually for the obligations of the partnership. You see the UK Limited. The UK Limited was quite popular in the past because it's a relative flexible company type. with less capitalization requirements. However, due to Brexit, the UK Limited is not an option anymore. And actually, the most popular type of legal entity used for foreign companies to start here their business, or for foreign individuals to start here their business, is actually the German limited liability company, abbreviated GmbH. Why is this? On the one hand, because you are not liable for the obligations of the company. It's a company structure where you can, as a shareholder, direct the management. You can give direct explicit directions to the management what to do. That is not possible with all the other types of legal entities. And there are certain more advantages which I will describe later on. Another one which is sometimes quite popular is the one below the limited liability company, the entrepreneurial company, abbreviated UG. That's basically a little GmbH, very similar structured like the GmbH, but less capitalization requirements. It's only €1 you need for capitalization. The reason why still the GmbH is more often used is, from my perspective, a reputational one. The GmbH is a very common type of legal entity, even used by big companies like, for example, Robert Bosch, who you may know. While the UG is more a new type of legal entity. We have it already since approximately 10 years, but still it's connected to it. It shows that your business is in fact small. If somebody sees that your business is a UG, he thinks that you have a small business, and clients usually take care of their reputation and then more often choose the GmbH. And at the very bottom, you also see the registered branch. When you decide not to open a subsidiary in Germany, you have also the chance to open a registered branch. In fact, it's not chosen very often. Why is this? The registered branch is not a separate legal entity. It's let's say this way. It's a part of the foreign mother company, and therefore you have to submit to the German commercial register massive documentation regarding the foreign mother company, and you have to translate all these documents. You have to certify them, and they have to be legalized. So the registration process is very burdensome, and so clients from abroad usually do not choose the registered branch as an option. In summary, the GmbH is the most popular choice, and then maybe even the UG for smaller companies, but that's it. All the other types of legal entities are not quite common when you start your business. But when you continue your business, of course, you can switch a GmbH, for example, into a stock corporation. It's you have to do some administrative stuff and have to bear some costs, but it's still possible. So it's not a final decision you make, but it's an important decision you make. So taking a look at the evolution of the company, and here permit me to use the GmbH because that's probably the most interesting company for you. In the early stage, in the early phase, when you consider all the questions and try to find answers, what's your purposes, what's your interest, choosing a company name, finding the right seat, renting a business address, etc., etc. From a legal perspective, in this stage, you are already a partnership under civil law, which means you are personally liable. Therefore, you should very soon come to the status of a pre-company, which you see in the middle. The pre-company is characterized by that you have already executed the notarial formation deed for the GmbH, which also includes the articles of association. This is basically the start of the formal formation procedure in Germany. Yeah? At this point, when the notarization took place, the company can already act, but when it acts, for example, sends letter to business partners, it still has to indicate that the company is still in formation. There's a little abbreviation you have to attach to the company name until registration is completed. And of course, you still have a certain liability risk, which only ends upon registration in the commercial register. Yeah? But again, you're already able to take part in the German market to, for example, sign contracts or to hire an office space, etc., etc. This is all already possible. When you have notarized the formation deed, the pre-company already exists, but in order to get the registration process completed, you still have to accomplish further measures. One important thing is that you need a bank account. You have to open a bank account, and as you may know from banks, they are very formal. They expect from you to submit a lot of documents, to file a lot of, to sign a lot of documents. That may depend on your region. When you're from the European Union, it's usually much more easier than when you come from abroad. When you have opened the bank account, of course, you have to make the capital contribution into the bank account. I come to that point later on when I talk about capitalization, or there's also the possibility that you do not make a contribution in cash, but a contribution in kind, which means, for example, that you contribute a piece of real estate, a machine, or something like this into the company. Of course, such contribution in kind then needs to have the value, the corresponding value. I come to that later on too. And of course, in this stage of the registration process, the managing director has to file a commercial register application in notarial form and have to submit it to the commercial register. In such commercial register application, the managing director has to make certain confirmations, for example, that he's not received criminal punishment for certain economic crimes, etc., etc., that he never filed insolvency with a previous company, etc., etc. So you have to be lean here. Upon registration in the commercial register, the formation procedure is completed, which means that you have a full German legal entity with all rights and obligations. The company, including the managing directors, shareholders, and articles of association, however, are from that point in time publicly available in the commercial register. So everybody can take a look in the commercial register and sees who is the shareholder of your company, who is the managing director of the company, and what is the content of your articles of association. That is something you have to keep in mind. That this company is relatively transparent. Okay. So now giving you a nutshell of the GmbH. You have basically 3 levels of the GmbH. You have the shareholders. It can be one shareholder or more shareholders. You have the company itself. The company is governed by the articles of association. The articles of association state the formalities regarding the shareholder meeting. It states the representation authority of the managing directors. It states the majority requirements if you want to pass resolutions, etc., etc. And you have the managing directors who represent the company vis-a-vis third parties. The managing directors can be limited in their acting by enacting bylaws, by adopting bylaws. This is an option. This is just an option in such bylaws. For example, you can state that managing directors, for example, if there is an important decision to make at a certain amount, that they have to get the confirmation, for example, from the shareholders or from the supervisory board. Of course, you can also install a supervisory board in the GmbH. Yeah? What else is to say? Shareholders, as I already mentioned, are usually not liable for the obligations of the GmbH, except if they pierce the corporate wheel, which means basically, for example, that they mix the assets between the shareholders and the company. You have to treat your company separately as a separate legal entity, and if you do that, you are safe as to liability. Yeah? Okay, the managing directors are personal liable to the company if they breach the duties and obligations, at least with negligence, and if the company suffers damages from this misconduct. The duties of the managing directors are governed by the code for the GmbH. There's a separate code for the GmbH. However, the managing director has a certain discretion in its decisions. The law recognizes that the managing director is a businessman, and that businessmen have to make decisions, have to take arguments from both sides, and then have to make a decision. And sometimes the decision may be even not correct, but it's still within the discretion of the managing director. So not for every wrong business decision the managing director is liable. If he follows the rules, he's not liable. Yeah? Okay, finally, we come to the topic capitalization. Basically, there are 4 ways to fund your company. We have the stated capital, which is the most important in the early stage, and I come to that soon. Of course, you have third-party funding. You can lend the company money. Of course, the shareholder can grant a shareholder loan, and of course, you can also make payments into the capital reserves, which a company can use to business in Germany to make investments. But coming back to the stated capital, which is the important type of funding because it's required under mandatory law, you have to consider how the amount of the stated capital your company should have, and you have to make this decision prior to the notarization of the formation deed. The minimum stated capital for a GmbH is 25,000. As I already mentioned, for the UG, it's only €1. Out of these 25,000, at least 12,500 have to be paid in cash. Otherwise, the registration process will not be completed. So at least 12,500 you have to pay in. If you decide that you do not make cash payments, and this decision you also have to make at an early stage, but that you contribute something else, real estate, a machine, whatever, it has to be sure that this contribution in kind corresponds to the 25,000 euro. It is not sufficient if it only corresponds to 12,500 euro, but only 25,100 euro. And you have to prove this vis-à-vis the commercial register with a valuation report by an accountant. So if you choose the contribution in kind, the whole registration process will be extended in time. Of course, you can, at a later stage, also increase the stated capital. You need a 75% majority for passing the shareholder resolution, but that's not a problem if you're the sole shareholder. Usually companies, if they start in Germany, they choose 25,000 as a stated capital, which is the minimum, and then later if they grow, they and maybe take other investors in, they increase the stated capital. This was now a very fast overview over German corporate law and all the hurdles you have when you form a company, register a company, set up a company in Germany. And yeah, I'm happy to answer any question in this respect afterwards, but at this point I pass over to my colleague Sebastian von Rüden, and also again to my colleague Nikolai Wessendorf. Thank you.
Yeah, thank you very much, Sven. We will now talk briefly about what is important when setting up a company in Germany from an IP law perspective. However, against the background of the different IP rights, there are a large number of different questions and challenges, which of course we cannot address in the time table available here. And therefore we have a certain agenda, and perhaps Nikolai can go to the agenda slide. And if, as you see there, I would first like to give you a very brief overview of the IP rights that are of particular importance in Germany and which you have to deal with when you're doing business here. And then I would like to focus on trademark law in particular, because trademark law is the most important IP right at the beginning of a business activity, because the trademark law regulates questions concerning the use of the company name, as well as questions regarding the use of names of products and services. And if you bear in mind that every company first needs a legally protected name under which it can conduct business, and next must ensure that it can use the names of its products and services free of in a very legal, secure way and a conflict-free manner, then trademark law is the focus of attention at the beginning of the business activity. So perhaps the next slide, please. So we will start then with an overview of the most important IP rights. And in this context, it is important to note first that all of these IP rights, which are listed here on the slide, grants their holder on the one hand a positive right of use, and on the other hand negative prohibitive rights against third parties who infringes their intellectual property rights. And it is therefore important for you on the one hand to make timely efforts to obtain own IP rights, and on the other hand it is equally important to take precautions and measures to avoid conflict with IP rights of third parties. And having said this, the most important IP rights in Germany can be first divided into technical intellectual property rights on the one hand, and into non-technical intellectual property rights on the other hand. And as you can see from the slide, in the first group, these are the technical intellectual property rights. There are patents and utility models, and these protect technical inventions. And then we have the group of the non-technical IP rights, and these are in particular designs. They concern the protection of the visual appearance of articles of daily use, of jewelry, or fabric patterns. And secondly, the second group of the non-technical IP rights are trademarks and other labeling rights. And these include names of goods and services and company names, as well as names of intellectual works, such as the title of songs, for example, of books and domain names. And the third group are copyrights, and copyrights protect intellectual works such as text, music, images, films, and software. And beyond the technical and non-technical intellectual property rights, the protection of know-how, that is the legal protection of trade secrets and of confidential information. This protection of know-how occupies a special position within the system of intellectual property rights, as you can see here in the middle. And since early 2019, the Trade Secret Act now regulates the protection of trade secrets in Germany. And in the next slide, we see that apart from the division of intellectual property rights into technical and non-technical intellectual property rights, there's another very important classification of intellectual property rights, namely in registered rights on the one hand and non-registered rights on the other hand. As you can see on the left side, patents and utility models are registered rights. And there are also the registered trademarks, and the registered designs. And this means for all these rights, you have to apply for and register them with the respective patent and trademark offices in order to create them. With regard to these rights, in other words, registration and grant are required for protection. In Germany, the respective trademark office is the German Patent and Trademark Office for all of these rights. And in addition to these registered IP rights, we have also unregistered IP rights on the right side. And these are rights which, if further requirements are met, these rights can be created without registration. For example, solely by an act of creation, what applies to copyright law, with the start of use in the course of trade, and or by gaining recognition in the relevant public. And these unregistered IP rights include, for example, copyrights, the non-registered German trademark, or the non-registered community design. Next slide, please. So we come now to the second topic. As I said before, this was only a very brief overview of the most important IP rights in Germany. And as discussed at the beginning, I would like now take a closer look at the trademark law. And then you can see from the next slides that there are very different forms of trademarks in Germany. And the first slide here shows the classical forms of trademarks. These are word marks, like for example, Adidas, Volvo, Just Do It here from Nike, or figurative marks, or a word figurative mark, which is a combination of a picture element or a word. So and then the other side, please, the next slide, please. As you can see from the next slide, besides these classical types of trademarks, you can, under certain conditions, in particular, also protect as a trademark the three-dimensional shape of a product, a color, for example, the sound or a combination of a sound, or a combination of image and sound, or even a holographic image. These are modern forms of trademarks, and they can also now be registered in the register of the German Patent and Trademark Office. Next slide, please. However, at the beginning of your entrepreneurial activity, the classical word mark is of greatest importance, because it is important to ensure above all that your own company name under which you intend to do business in Germany and the names of the products and or services that you intend to offer and distribute can be protected by trademark law and do not interfere with already existing identical or similar trademark rights of third parties. And as you can see from this next slide here, there are 2 points which are of great importance in this respect. First, the product or company name should be eligible for trademark protection. No, can go back. It's the same slide. Yeah, here we are. Because for a product or a service name to be eligible for protection as a trademark, the brand name in question must above all be suitable to serve as an indication of origin. This means it must be capable of distinguishing the goods or services from one undertaking from those of other undertakings. In other words, the name must allow to distinguish branded goods and services of an enterprise from the products and services offered by competitors. And this is particularly lacking in case of a purely descriptive indication or purely promotional claims. And I would like to give you a very well-known example. The word Apple is eligible for trademark protection for computers and other technical devices, but not for the services and goods of a fruit trader. This is because for the services and goods of a fruit trader, Apple would be a merely descriptive indication of the goods marketed and would therefore not be distinctive in relation to other fruit traders who also market and distribute apples. Apart from the eligibility for protection, it is of greatest importance that your selected name should not interfere with prior trademark rights of third parties. In this context, it should be noted first that not only already existing prior identical trademark rights of third parties may conflict with the selected name, but also similar prior trademark rights. And important is that such a similarity can exist visually, orally, or conceptually. And therefore, a conflict with older trademark rights can arise more quickly than one might think of in advance. And why it is so important to avoid a conflict with prior trademark rights of third parties? This is because an infringement of IP rights of third parties can have serious consequences for the infringer. If identical or confusingly similar third-party trademark rights already exist, the owner of the earlier rights can prevent the registration of the younger trademark by means of opposition or cancellation proceedings before the Patent and Trademark Offices. And he is also entitled to different claims, namely to a claim for the prohibition of use of the infringing mark, as well as for destruction of the unlawfully labeled products. He has claims for information and rendering of accounts and damages, and he may bring all these claims before the courts. Therefore, perhaps the next slide, please, Nikolai. No, the next slide.
Yeah, can you see? I'm sorry, it's loading a little bit slow, but okay. It's already on the next slide. So let's wait for a second. Maybe it's coming. Can you see?
No. We need the next slide. Yeah, it's coming now, I think.
Perfect.
And against this background, the following procedure is urgently recommended before starting to use a company name or a product and or service name in Germany. First, from left to right, in order to obtain trademark protection for the respective name, the product name or the company name, it should be examined whether the name in question can serve as an indication of origin and can therefore generally be protected under German trademark law. Secondly, a professional search for conflicting third-party rights should be carried out in the relevant register in order to avoid the infringement of third-party trademark rights. In this context, it is also very important to know that neither the German Patent and Trademark Office nor the European Intellectual Property Office examine in case of a trademark application whether identical or similar trademarks have already been registered. Therefore, it is important that you search yourself. And thirdly, provided that the respective name is protectable and does not interfere with third-party rights, the name in question should be filed either as a national German trademark with the German Patent and Trademark Office or as a European Union trademark with the European Union Intellectual Property Office, with protection then for all 27 countries of the European Union. And fourthly, once the mark has been registered, it should then be monitored, because this means trademark owners should conduct post-registration searches for new identical or similar signs at regular intervals to protect their trademark and, if necessary, to defend it effectively. So far, this is all from the IP side now, and I will pass them to Nikolai to speak on other issues, I think in particular about data protection law. Thank you very much.
Thank you, Sebastian. Thank you. One thing I learned from you was that it is very dangerous to say at the beginning, well, it's only brand, you know, we can change that later. We start our business, suddenly you scale and you're renowned, you put a lot of investment of the reputation of your company and you struggle with all what you've been outlined. So again, I learned from you, it is very much important then when making, even starting when making thoughts, right, putting energy into that, starting to really wonder, can I actually use that brand? So I think very important information, and we will jump to some further and final information. Final section for this webinar today, before we jump to the questions. What to bear in mind when you do business locally through your local subsidiary or your local company, or also doing services from abroad. You need to follow the local laws, and the local laws are European laws. As said before, we have a large and wide European legal framework, but on the other side also very specific local laws, even sometimes state laws. And one thing we want to look closer at is consumer protection. Consumer protection became over the last decades more and more important. It is a little bit, some would say, contradictory to the principle of the freedom of contract, because as an entrepreneur, as a company, you cannot basically, you know, conclude any contract you want with the consumer, you know, set up your T&Es, terms and conditions as you want. There are very specific laws, what you can do and what you can't do. And it is not that, you know, if you conclude on an invalid clause, you wouldn't have a problem. The situation might be that you fall on a legal level that is exactly what you didn't intend to do. So again, first recommendation, take a close look when setting up your contracts, your terms and conditions, what impact that might have from a consumer protection perspective. Also, you have large and wide obligations regarding information. For example, when doing business over the internet, doing e-commerce, selling goods over the internet, the consumers have a right of withdrawal they need to be informed about. The whole idea is that when I order something home, I need to look at it. I want to maybe even try it, and I even want to touch it and make my decision and make up my mind if I really want to keep it. So the European lawmakers decided to grant each individual, each consumer in this case, the right to do so within 2 weeks. And you, as an entrepreneur, as a company, need to inform the consumers about such right. And if you don't, you have a problem, because then the people can still send back their goods even a year after they bought it. So and get back their money. So even information obligations and the compliance with such information compliance can have wide effects. So second recommendation here also take a very close look on information obligations, especially when doing business over the internet. And further, the law provides for many very specific other obligations in electronic business transactions, not only to consumers, but also regarding the area B2B, so business to business, which probably might be also very relevant for you. So here, bear that in mind. And a second recommendation, when you look at your terms and conditions, when you set them up, when the first time you build your website, you build your legal framework, your contracts, it is very tempting, you know, to simply go and copy paste legal text from other competitors' websites or whatsoever. This is very risky to do so. You can not only have not what you want, but maybe exactly the opposite. So third recommendation when it comes to TNCs, take the time, spend the money, and have them challenged by a lawyer that gladly will guide you and support you on this. And as you're also, some of you are familiar with the whole insurance sector, InsurTechs, there is, of course, and this is going to be the last point we're looking at, of course, you'll find a lot of regulation in that area, which also relates to information obligations, to consulting, obligations on consultation, and also documentation. In laws that you would find as not a lawyer, maybe even hidden. So another good reason to ask for guidance on this. Let's take a last look, and let's look in the details in regulatory. We picked some topics which seem to our understanding very relevant for you. Data protection in particular, and insurance. As the topic of this series, of this tour, is also InsurTech, and some of you are maybe already engaged, involved in the European market, doing insurance business, maybe as a service provider, but maybe even you know, aiming to become an insurer once, or already are insurance or an intermediary. So let's take a closer look. Data protection. Data protection, I think you've heard of GDPR. GDPR now is something that is almost known to everyone doing business, internationally business in the world. GDPR is the data protection framework in the European Union, which applies directly to everyone doing business in the European Union. Of course, there's a distinction when you do business from the outside. Not in every case GDPR applies, but when you turn to the market, when you do offer goods and services to the market, even if you only do website tracking, if you are only monitoring the behavior of website visitors, immediately GDPR applies. So for example, if you're residing in India and you're opening up a website in German in order to make business with Germany, in most cases, German laws will apply, or European data protection laws apply for the tracking of your website. So that framework is not only about websites, it's not only about data privacy statements and good policies assuring that you will take care of privacy. It goes way deeper. So when you develop products, when you develop online services, we strongly recommend to bear in mind and actually integrates data protection in the DNA of your product, because this can not only be a USP, a unique selling point, but it can be existential and vital for your product in order to be sold to the European Union. What we experienced with the European with the GDPR coming into place, many German companies made the decision to kick out great services from the US, for example, and because unfortunately they weren't able to comply with a GDPR. So that can be actually a real killer. So look into GDPR, and as we see it from today, GDPR seems to be like an export product from the European Union, looking at California, looking at Singapore and other countries and states over the world that are taking considerations in trying to implement data protection laws like GDPR. So this seems to become the new standard. So it's a well investment from our side. Last one, insurance. When you deal with insurance, you will have probably two situations you face. Either you want to go into a cooperation with one of the old ones, right? With one of the great ones, like for example, AXA, Allianz, Munich Re, and others. And they are looking for innovation. They are looking for service providers. When it comes to car insurances, and I have an accident, they want someone that uses, that can provide KI in order to determine how did that accident happen? Is it fraud? Is it not fraud? So when you're in that situation, you will suddenly find yourself in negotiations with a large large corporation with a large legal department and negotiating cooperation agreements and service agreements. So that is obviously something when you suddenly realize how relevant all that legal framework is. So there, also our recommendation: get your partner, get a legal partner, and do well in negotiations of contracts. When you address the market yourself directly, be in mind insurance is regulation. Okay, so that is also in part in order to protect the consumers, the insureds, but also to protect the whole insurance market, to keep it stable, to keep the company solvent. So there, for example, you have, when it comes to distribution, a European law, which is a insurance distribution direction, which has been implemented in several laws in the national member states, also providing for information obligations, documentation obligations, and others. When you do that online, when you have a buying flow, you got to be really careful that you have the right check boxes, the right information, the right documents in place to be downloadable at the right point in order to make a successful and secure business. So I think that's that from our side. Colleagues, what do you think? Should we jump over to the Q&A section?
I think we should.
Sure.
Right. We have a couple of questions. There are 8, and let me pick the one on GmbH, and I will not be able to answer it in full, but Sven, you might be able to help me with this. The question is, how does a GmbH compare with a registered branch in terms of costs attached? And the second question on the topic of GmbHs is, what do you mean by managing directors? Usually a company has only one managing director. Well, what we mean by managing director is called Geschäftsführer in German, and you may choose to translate this as statutory executive. Now, a limited liability company under German law, a GmbH, needs to have at least one Geschäftsführer, one statutory executive, one managing directors. It may have more. So I think that's that part answered. What about the costs, Sven? Shall we answer this straight away or park it?
No, sure, we can do that. So if the costs are for you important, let me say the following. From all registered branches I so far opened and registered for clients, the branches were always the most expensive. And why was this the case? No matter from which country the mother company was. The point is that of course, you do not need a stated capital. You do not have to pay money in, but you have to get all these documents. You have to get them translated. You need the you need an apostille or legislation for the documents, and all this usually makes the registration process much longer. I already had cases which took months, yeah, because foreign branches also for the commercial register not common, so they go more into detail, and in particular if time matters, the registered branch is not recommendable. If money is for you essential, or if the costs are for you essential, then it's better for you to take the UG, because that was another question which was raised. The UG has no minimum stated capital of 25,000 euro. €1 is basically sufficient. That's similar like the UK Limited. The UG was once enacted by the German legislation as an answer to the UK Limited. And so basically the UG is the cheapest way to enter the German market, because the formation process is also relatively standardized, and it goes also relatively fast. But the branch just look like being the less expensive choice because you do not need the stated capital, but usually the registration costs for advisors, for translators, court fees, etc. is usually higher than when you choose a standard legal entity such as the GmbH or the UG. Yeah?
And Sven, there is another question on how to set up a GmbH, which is how much needs to be paid in. 25,000 euro was mentioned as minimum capitalization, out of which half has to be paid in cash. And the question is, when can the company be registered? Can it be registered already once the first 12,500 have been paid in?
Yes.
What about the second half?
The second half does not have to be paid in at all, but of course, in this respect, you are still liable later on as a shareholder, but it has not to be paid in. So basically, if you choose a stated capital of 25,000, you pay the 12,500 in, you prove the pay-in vis-a-vis the commercial register, the formation process gets completed and your company is getting registered.
Okay, thank you, Sven. Thank you, Jörg. Maybe I go with the question, which is the situation, what kind of visa, what kind of permit you need. So, as I understand the correct is when you're on a certain permit on a certain visa in Germany, and then you want to stay in order to open a business, you will need to apply for that separately, because it needs to state in your permit that you are also allowed to open up a business. So this is a full procedure. It might be simpler, it might be easier for you to go through the whole process while you're already in the country, instead from doing it far away and dealing with authorities and the different stakeholders you need to involve, also to find founding partners, financial investors and whatsoever. So that is obviously great change when you're working at the university. You have a good idea through research, through innovations you have. It's probably a good idea to start the whole process to get a permit to actually open up a business, and get support also from people like NRW.INVEST, talk to lawyers like us. That's a great chance. The same applies. Sorry, I was interrupting. Shall I just add one answer to a similar question?
Sure.
Which would be, it's the same question. I think already open up, started the process in another EU member state. That process doesn't seem to go fast enough. Process meaning setting up a company, applying for a permit, which is something to our understanding. You cannot refer to the foundation of another country in another of a company in another country when applying here for a visa. Of course, you have a directive which governs the whole freedom of movement and also of establishment in the European Union. So once you have the visa, you can do and go to other European countries and do your business. Maybe important information for you to know. When you successfully have founded a business in one country, for example, in North Rhine-Westphalia, and you want to start and set up other companies in other EU member states, you can do so. Once you have successfully gone through that process, you can open up subsidiaries in a way more easier way, as privileged by European law.
Oh, those are big questions. So I think so that's we have a different startups is we work with the startups on special stadium from the development, and I see this is a lot of questions about UG form. Yes, so and that's a little so I'm surprised, because I think so that's only startup or young company with good idea, with good technology can be successful in Germany. So, and we are not work with I don't know, so we don't have so experience, good experience with the IG, because IG is you don't have so financing, you don't know things, only my maybe idea, and maybe that is I don't know, this is not chance. So what is important, it's the contact, the business contact during, or with supporting from NRW.INVEST, with supporting from Chamber of Commerce. That's like first step. It's from Chamber, from the startup from abroad, on the startup from Germany. It's some way. And good contact and good presentation of your product, and find the customer for your product or partner. That's the number one for good implementation of your business. But yeah, so thanks. So step to step, and in Nordrhein-Westfalen in Germany, we don't have a magic. It's like in other country, and it's normal. It's business development is the same for small company and big company, but we are ready to support you in this way.
Great. I see there are two more questions coming in right away. One, Jörg. If I'm correct, this is aiming for tax questions.
Mm-hmm.
You want to?
I will take that one. The question is, we've just set up a limited liability company, a GmbH in NRW, but for the first financial year, we are not expecting to earn any income. Will we have to pay tax? Now, in terms of corporate income tax, the tax base for corporate income tax is the net result, the net taxable result. If you have no income and only have expenses, you cannot possibly generate positive net income. So the answer is very clearly that there will not be tax. In simple terms, there will be tax as soon as you start generating a positive taxable income. If you generate losses initially, even if you do so over a number of years, say for 2 or 3 years, these losses, you can carry them forward and apply them against positive taxable income earned in later periods. And in Germany, there is no limit in time for carrying these losses forward, in principle.
Okay, thank you.
Maybe for, I don't know, so want you answer any questions? But
I can see that someone in the chat was asking for the answer to that question they posted in the Q&A session, which we're hoping to have answered at least already a little bit more general, so for the full audience, which was the question: when I started and initiated the process of company building in another EU member state, and this process is taking too slow, can I go to Germany and continue that process of applying for a permit? And our answer was, generally, you can't simply take over what has happened in another member state, although it is harmonized and also governed by a common directive. But when you apply for visa, you have to do initially that in the member state. You do the full process. That is like the general rule. So I hope that is a proper answer to the question.